Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. We are going to discuss the judgment of a constitutional bench as to whether the circumstantial evidence can be used to prove the demand of illegal gratification under Section 13 of the Prevention of Corruption Act 1988. This is a complicated issue. It can't be said in toto that if a person dies, so the charge or the statement cannot be marked. But still, the other circumstances, yes, definitely, if they are proved, the illegal gratification definitely can be proved. This is what is stated by the Constitutional Bench, consisting of 5 judges: Honorable Justice S. Abdul Nazir, B.R. Gawai, A.S. Bopanna, 4th V. Ram Subramaniam, and 5th Madam B.V. Ragaratna. The related case is Neeraj Datta Vs State within brackets National Capital Territory Region, Delhi, in criminal appeal number 1669 by 2009 on 15th December 2022. So please remember, Neeraj Datta, she is an electrical engineer. She was actually an electrical engineer in Delhi. First, let us know the facts of the case. There is one person by name Ravjit Singh. His name is Ravjit Singh Sethi. He has got a shop. He wanted to get electrical connection or for the installation of the electricity meter in his shop. He has approached the electricity officials. They directed him to approach the concerned AE, Neeraj Datta. Actually, he approached her, then she demanded 15,000 for the giving the meter connection or supply, electricity connection to his shop. Of course, some bargaining took place. Ultimately, the issue was settled. She demanded 15,000, then it came down to 10,000. She is ready to accept that money. But Ravjit Singh Sethi is not willing to pay bribe. He is against corruption. Therefore, he approached the local Delhi anti-corruption bureau sleuths and they arranged a trap for Mrs. Neeraj Datta. Right, as arranged on, so maybe on 19/4/2000. 19/4/2000. So what she has done is, she asked this Ravjit Sethi, yes, to come to her house and pay the so-called 10K. So he went to her house, but she was very careful. So she asked he asked Sethi to give the cash to some other person. A2 is her JE or some lower cadre person. But the ACB people, will they keep quiet? They rounded both of them, of course, subjected them from the so-called test, phenolphthalein test. So due to which the hands were turned into pink color. So case was booked against them. Right. While they normally, you may be knowing, it takes a lot of time to file a charge sheet. So while the charge sheet, the trial is going on, before the trial commenced, the concerned Rachit Singh Sethu, he died. This is the main problem. So when he died, normally the evidence may not be of such value, and here the case is a very strong case. Now the reference has come, actual lower case convicted, a reference has come that the question is, the reference according to 115 of the Indian Act, the reference means whenever the lower court gets a doubt regarding particular aspect, it can be clarified by the higher courts. This is reference. The reference is like this: whether the circumstantial evidence can be used to prove the demand of illegal gratification, because the person who gave the money, the person who was present at the time of the trap, he was not traced. he was not alive, but he has given evidence that there was a demand for illegal gratification, and definitely the judge wanted to prove it. So whether it can be done or not. So this is the important point. Now here you have to remember section 154 of the Indian Evidence Act 1908. Evidence Act clearly says 150. What is 154? You may know it is hostile witness. Whenever a witness turns hostile, normally you will be subjected to cross-examination. This is questions by a party to his own witness. Normally, the cross-examination will be done by the other party, but here the cross-examination will be done by the same party, by the own party. So, section 154 says, the court may, in its discretion, permit the person who calls a witness to put any questions to him which might be put in cross-examination by the adverse party. That means just like adverse party, you can put questions to him. But please remember, court must carefully analyze a hostile witness. So please remember, the evidence of the hostile witness, as far as it is supports the prosecution, can be relied upon. So this is most important. So here, if any person dies, yes, his evidence cannot be recorded, but the other circumstances, what I call as section 6, the Rachit State, yes, definitely they will become relevant and conviction can be given basing on the circumstantial evidence also. So sometimes it happened in my own case when I was working as a police officer. Even though I think I have told you about a week back in the class, even all the witnesses turned hostile. Please remember, basing on the evidence of the investigating officer and the timely sending of the FIR to the court and the timely sending the inquest report to the court, yes, they have helped the IO, helped me literally to secure a conviction, because the witnesses, the hostile witnesses, when they turned hostile, they spoke all the facts. The only thing is they were not sure whether this is the same person or not. Only thing that much. So then, basing on other circumstances, yes, they gave the evidence. So according to section 152, please remember, the court may permit the other evidence to be gathered and the conviction can be given. So court can take the facts and circumstances into consideration, and definitely they can be used to prove the demand for the so-called illegal gratification. Please remember, there is no legal bar to give conviction even upon the testimony of a hostile witness. Very important case. I will speak in Telugu for a few minutes. So, ఇది చాలా టిపికల్ కేసే. సహజంగా ఒక మనిషికి మీకు ఇప్పుడు అర్థమయ్యే ఉంటుంది, ఆ నీరజ్ దత్తా గారు డిమాండ్ చేసింది, ఇతనికి ఇష్టం లేదు రవ్జిత్ సేత్కి. ఇతను డబ్బులు ఇచ్చాడు, ఇచ్చి ఏసీబీ వాళ్ళకి పట్టించిన ట్రయల్ టైంలో చనిపోయినప్పుడు ఇతని ఎవిడెన్స్ అంతా పోతుందిగా. It can't be a dying declaration because it is not relating to the facts leading his death. కాబట్టి డైయింగ్ డిక్లరేషన్ 161 కిందే ఉంటుంది. ఎవరు మార్క్ చేయాలి? లేదు. అందుకని ఈ ఎవిడెన్స్ కాకపోయినా డిమాండ్ అనేది ఆల్రెడీ చెప్పున్నాడు, చుట్టుపక్కల విట్నెస్ ఉన్నారు కాబట్టి ఆ డిమాండ్ మిగతా ఎవిడెన్స్ ద్వారా ప్రూవ్ అయితే ఆ డిమాండ్ అనేది బేస్ చేసుకుని, ఈవెన్ దో ట్రాప్ అనేది ఇప్పుడు మనం ప్రూవ్ చేయలేదు ఎందుకంటే ఆ మనిషి డైడ్ కాబట్టి, సో మిగతా ఫ్యాక్ట్స్ మీద డెఫినెట్గా శిక్ష అనేది వేయవచ్చును. వెరీ గుడ్ కేస్ ఫర్ ప్రాసిక్యూషన్. ప్లీజ్ రీడ్ ద కేస్ లా అండ్ ఎన్రిచ్ యువర్ లీగల్ నాలెడ్జ్. With this, I am stopping. Thank you very much.